All right, on the docket, 10 o'clock, another oral argument session of the 5th District Court of Appeal.
Your state's not here.
I think I see Mr. Palace.
There you go. He's hiding. All right, nice.
There you go.
Apologize for hiding, Your Honor.
It's all right. So we have one case on the docket. It's Devontae Tyree Charles Donaldson versus the state. I'm Rand Wallace. I'll be presiding today over this case, and I have joining me. What's that?
Well, there we go.
I have joining us on the panel Judge Brian Lambert from Marion County, Judge Jim Edwards from Seminole County, and Mr. Pannell. Should I assume 5 minutes for rebuttal?
5 minutes is good, Your Honor.
Okay, you may proceed.
May it please the court, my name is William Pannell and I represent the appellant Devontae Donaldson. It's our position in this case that initially the trial court committed fundamental error by providing the jury with the possession presumption for burglary because the state failed to establish, or the evidence failed to establish, that Mr. Donaldson was in a personal and exclusive possession of the stolen property. If the court does not find its fundamental error, we would argue it's ineffective assistance on its face, because there's no legitimate strategic reason under the facts of this case for the trial attorney not to object to the provision of this instruction.
So, Mr. Pannell, you're saying that the speculative nature of the evidence was there was another person in close proximity to the stolen property in the car. Is that correct?
Correct. First, no one saw Mr. Donaldson in possession of this yellow Norwesco container. No one testified to that. And then the container was found on the passenger floorboard where another individual was sitting in the passenger seat.
What did Mr. Donaldson get in the car with? Wasn't he carrying some type of a bag? Is that correct?
He was carrying what the deputy described as a laptop or purse style bag. And that's from page 185 of the trial transcript. And
that was a bag that was not, they did not observe him carrying when he went into the backyard prior to him coming out of the backyard, correct? That's correct.
So it's our position that would be certainly evidence in support of the state's argument that there was a burglary here, but it doesn't support the inference instruction.
Did the bag come from the house?
I don't believe there was any evidence that the bag came from the house. I believe the evidence from the victim was that the container was missing.
And the yellow container was confirmed as one that would have been in the house.
That's correct, Your Honor.
Okay. And then the bag and the container were in the car.
There was while the police were pursuing Mr. Donaldson, apparently a bag was thrown out of the car, but the container in question was located on the floorboard of the passenger seat where another individual was sitting.
Okay.
So it's our position that this court's decision in Midget is instructive, where it says that the inference instruction, or the instruction permits an inference of guilt based on possession of recently stolen property, only applies where the evidence shows that the accused possession of recently stolen goods is personal and exclusive. Quote, the fact that the property was found in a location shared by the defendant and another individual does not support the inference instruction. And it's our position that's what we have here. Simply because Mr. Donaldson was in the car with another individual and the stolen property was found at the foot of the other individual does not establish personal and exclusive possession by Mr. Donaldson. And there's other cases.
If the two are acting in concert, then the exclusivity can be for both of them, correct?
It can, Your Honor, but there was no evidence of that other than the fact that they were riding together.
So the only evidence we have here is he was seen getting in and out of the white SUV by a witness at the hotel. He was seen getting in and out of the white SUV by a police officer who identified him as the person who went around the back of the house without anything in his hands and comes back out with a bag. And he's followed by the helicopter in the car. He gets in the driver's seat. Another police officer that we haven't mentioned before sees him in the driver's seat. Another police officer sees something thrown from the car that they're pursuing in the helicopter that just happens to be a backpack with his wallet and ID in it. And you're saying it's just his bad luck. He just happened to be in the wrong car at the wrong time and he has nothing to do with it, that there's not proof from which a jury could find that he indeed was involved with this other fellow?
I think there's significant evidence or there would be legally sufficient evidence to support a conviction of burglary based on the facts in this case. I don't think there's any way around that. I think the problem is the inference, and I don't think they get the inference, and the prosecutor took advantage of that inference in closing argument. So there certainly was no other evidence there was no evidence that both these individuals and like in Midget, the defense was misidentification, that he was not the individual that burglarized his house. So I think there's a difference between legally sufficient evidence for conviction and whether they should have got the inference instruction. And Mr. Donaldson was prejudiced in this case because the prosecutor explicitly relied on this instruction to ask the jury to infer, based on his possession of this property, his guilt. And that's the danger when this instruction is improperly given.
And again, you're saying the impropriety is because it was not exclusively in his possession, because there was somebody else in the car for a period of time?
Correct, Your Honor. And that's supported by Midget Garcia from the 4th DCA, where they said the inference is not appropriate where the defendant was present with 3 other persons in a van. And the Dobbins case from the 2nd DCA, where they granted a JOA, and they said you could not infer because stolen items were found in a vehicle with 2 people, that he was in personal and exclusive possession. So
but in those cases, was he identified by a police officer as the person who went around back behind the house that was burglarized and came back out with something in his hands and got into the car in which they found the stolen property?
in the Dobbins case, there was DNA evidence linking them to the scene. So I think that's analogous. But again, I think respectfully that we're mixing apples and oranges. I think what the court is referring to is evidence of guilt without the inference, and we're arguing the inference was improper, and that's the error here. So I don't think the fact that the officer saw him go in the house and leave the house with another and come out with a bag, not the stolen item, but a bag, supports the inference. I think those are different. So unless because the way the instruction reads is proof of possession by an accused of property recently stolen. In this case,
you're stopping too short. You got to read the whole instruction. If you're going to complain about the instruction, read it all, because it does contain safeguards. It requires that the circumstances of the burglary have to be considered, don't they?
They justify a conviction of burglary if the circumstances of the burglary and of the possession of the stolen property convince you beyond a reasonable doubt that the defendant committed the burglary.
Okay, so it's not merely possession. It's that you've got to also consider the circumstances of the burglary. And second, it's a permissive inference. It's not a mandatory inference. It's not if you find A, then you must convict, correct?
I agree with part of what you said, Your Honor, respectfully. So it's certainly permissive. I agree with that. But you don't get to consider the circumstances of the burglary to determine whether the instruction is given. It says proof of possession by an accused of property recently stolen by means of burglary. Then that raises the presumption. But then the permissive part is may justify a conviction if the circumstances convince you beyond a reasonable doubt. So the first part is when the presumption applies, and the second part is telling them why it's not a mandatory presumption, it's permissive. So it's our position that the evidence that was observed by the officers in this case no one's testified that they saw him in possession of this yellow Norwesco container, personally and exclusively. So it's our position that based on Midget, Dobbins, and Garcia, that this instruction was improperly given, and because it reduced the state's burden of proof, it constitutes fundamental error. If it's not fundamental error, we believe it's ineffective on its face because there's no legitimate reason for trial counsel not to object to this instruction based on the evidence in this case. There would be, I can't conceive of, and I don't think anyone can conceive of, a situation where you want the jury to hear even a permissive inference that your defendant is guilty if you could prevent it. So,
But to follow through on that, wouldn't we have to find that the court would have granted the objection to that jury instruction?
of course, you have to agree with my argument that under the case law, the instruction was inappropriate. So I certainly agree with that. I mean, I think on the deficiency prong, I think certainly it'd be hard to argue there was not a viable argument against the instruction. But as far as prejudice, I think you would have to find that the instruction was improperly given. So, and we don't have any testimony or evidence about the identity of the other individual. And again, we have a misidentification defense like we did in Midget. So it's our position that the evidence is not sufficient to show that they're acting in concert to commit this alleged burglary. So for those reasons, we'd ask that the court reverse his conviction and remand for a new trial without the inference instruction.
Okay, Mr. Powis.
Your Honor. May it please the court. My name is Richard Pallas. I represent the state of Florida. It's our position simply that this was a valid instruction. It was proper for the trial court to give it. There's no error, let alone fundamental. And of course, because it would be such a meritless objection, there's no prejudice in trial counsel failing to raise this at trial. I think that the evidence more than speaks enough that that they could infer that this defendant was in possession of this container. He entered the property, observed doing so. He was there for 30 minutes, observed leaving with a bag. He was observed driving the same vehicle by multiple law enforcement officers during his pursuit. He exhibited erratic behavior, trying to avoid law enforcement, tried changing his clothes or removing his clothes while avoiding them. And of course, this container was found with change spilled out on the floor. Real quick to touch upon Midget. That case was the 3850 case regarding ineffective assistance of counsel. And this court was only ruling that it was a facially sufficient claim by stating that the defendant in Midget was only in the vicinity of where the burgled area was or where the property was found. Here, we have much more than that. We're not just in the vicinity of a building. We're shown actually entering property through the backyard. Of course, law enforcement confirmed soon after the defendant left that the window was broken. A rock was later found on the bed at a later time, likely used to break this. And the victim identified this particular container. I think that's a perfect inference that this container was taken from there. And to touch upon acting in concert, it was observed by, I believe it was not Deputy Fisher, it would have been Deputy Bennett. He saw the defendant exit the vehicle and approach the victim's home, enter the victim's home. When he saw him leave 30 minutes later, he testified that the vehicle actually pulled up to him, showing that I don't believe this white SUV was a self-driving car. Likely the passenger was obviously the person who brought this vehicle forward. And then he must have moved over back in the passenger seat because everyone observed the defendant driving the vehicle later on, especially at that time when he left. I think that as the case law has said, and I believe it's AL, just because there's two people in the car doesn't mean the defendant is this instruction's improper. In most of those cases, we don't have this evidence here. There's no evidence usually leaking or linking the actual defendants on the property. In the Dobbins case cited in appellant's reply brief, this defendant did not no one actually testified that they saw him at the property when any of these burglaries were committed. They only found the other passenger who was arrested at a later time. And it's important that that all happened in the span. He was pulled over about a week or a few weeks after the burglary was reported. And then people were found there again months later. He wasn't arrested until the DNA testing was done. And it was on one cigarette. And it's possible he could have just trespassed and left the cigarette with his DNA there. I don't think that that case is at all analogous to this, because he was apprehended in less than an hour. They saw him go in at 12. He left at 12:30. Deputy, forgive me for pronouncing this wrong, Lesesne sees him driving the vehicle during law enforcement's pursuit of him around 12:30. And of course, Mr. Fisher, Deputy Fisher, identifies him as the same person he saw at 4:30 and 12 o'clock being apprehended around 1 p.m. And just to touch real quick on prejudice in the effectiveness on the face of the record, I mean, this is an abuse of discretion standard. I mean, the trial court's ruling on that is presumed correct. So had this objection been logged, he's going to look whether the facts support the instruction, whether it's a proper instruction, and then whether it's necessary for the jury. I believe there's no reasonable probability the court would rule any differently, and certainly no reasonable probability an appellate court would rule any differently based on the facts that were derived in this case. And further, just to touch upon fundamental error when jury instructions rise to this, the Heathcote case is using a completely incorrect instruction. And that one, it was an attempt to commit an attempted sexual battery. And in the Yee case, it left out that a touching was done in a lewd and lascivious manner. Those are incorrect instructions, whereas this is an instruction that's been given since 1885. If there are no other questions, I will rely on my brief, and I ask that you affirm.
Okay, thank you. Mr. Pannell. You're on mute.
I apologize. To the extent that the state is arguing that the two individuals in the car were acting in concert, it's well established that mere presence at the scene of a crime without more is not evidence of principal liability or accomplice liability. So without more evidence that this other person helped in the planning or execution of this burglary, I don't think you could conclude that that person was acting in concert to justify this instruction. Again, I'd ask the court to separate whether they think there's legally sufficient evidence to support a conviction from the idea that this instruction was improperly given. Under this court's decision on Romero, even where there's ample evidence of guilt, ineffective assistance of counsel can be established. We believe we have established both fundamental error and ineffective assistance, and we'd ask the court to reverse based on the improper instruction.
All right, thank you for your arguments,
Thank
and
you.
we will be adjourned. Have a great day.
You too.